Njani molweni avusheni thobela nda. Today we are going to premiere the constitutional law, which we are going to answer the full question paper. This is the October-November examination in 2023, and we are going to answer the questions constitutional law. Okay, let's go and try to answer. On the other side, we have where we will be answering the question. Okay, we are going to do this thing in a fair bull where you should have answered the question. So without any wasting of time, well, let's start with the question. The question said, university students across South Africa have been demanding a decolonized and Africanized education for the past decade. Explain in what respects it can be argued that South Africa already has a decolonized system of constitutional law. So constitutional law meaning that we are talking about the rule of law, right? Okay. I hope that you have understood the question. University students across South Africa have been demanding a decolonized and Africanized education for the past decade. Explain in what respects it can be argued that South Africa is already a decolonized system of constitutional law. So, firstly, South Africa adopted this constitution in 1996. So, of course, you will said that sorry, I forgot to press edit. Firstly, you will say South Africa has adopted democratic constitutional, not constitution, in 1996, right? Then after writing that sentence, you'll come to the constitution and check the constitution. It makes it clear that supremacy of the constitution. And therefore, this is based on the section 2 of the constitution. And then you come here and you write that section 2 of the constitution stipulated that the constitution is supreme and any law which is inconsistent with it invalidated. So now you have written about the section 2 of the constitution that makes the law supreme, and any law which is the constitution which is consistent with it will be invalidated. This clearly means that South African democracy is based on the rule of law. All right. Then after answering section 2, you go and look for another section which is consistent with your question, and this is chapter 2, Bill of Rights. Then you can see that the Bill of Rights is a cornerstone of democracy. Then then you go and written that Chapter 2 of the Constitution is the cornerstone of the democracy. And the state is mandated to promote, protect, and fulfill those rights. I didn't write. To fulfill. Yeah. Okay. Now, let me put it like this. Now we are going somewhere. Now we have already showed that South Africa is a democratic country, and then the section 2 is made it clear it is superior, and any law which is consistent will be invalidated. We have already shows that South Africa is based on the rule of law, and chapter 2 is the cornerstone of our democracy, and the state is mandated to promote, fulfill, and protect those rights. Then you write the last one that, however, those rights are subject to limitation in terms of, say, in terms of section 36. Those rights are subject to limitation in terms of section 36. All right. Then after here we go straight down, 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 down to section Section 33, this one, just administrative action. We'll read it together with section, this one that I've skipped, the right to education, in the official language, which is section 29. So we'll read we'll took section 29 together with section section 33. Yes, with section 33. So of course, because of time, some you will see when I've already written. To 29. Yes, then you show that section 33, subsection 1 made it clear that everyone has a right to administrative action which is reasonable. Department of Education is a state organ in terms of section 239, and everyone As a right to education, let me say that education in their official language, official language or language of choice, as long as is reasonable, practicable, based on section 29. So yes, so according to section 29, everyone has a right to education in their official language or the language of their choices, as long as it's reasonable, practicable. Then I go forward, explain that according to section 3, subsection 2, paragraph A of the Administrative Act, this is a Promotion of Administration Justice Act. You know about it when you're doing IDR. Stated that the fairness of administrative procedure depends on the circumstances of each case. In the case of Maseta versus the President, Ngobo J stated that the fairness is based on flexibility and practicability. Okay? Then you put the real, then you are done. Then this is how you should have answered the question. Let me read it for the last time so that you know what the question says. The question says that the university students across South Africa have been demanding a decolonized and Africanized education for the past decades. University students, right? Explain in what respects it can be argued that South Africa already has a decolonized system of constitutional law. And this is how you should have answered. So you should have told them that South Africa has adopted democratic constitution in 1996. Section 2 of the constitution stipulated that the constitution is supreme and any law which is consistent with it will be invalidated. You must have said that South African democracy is based on the rule of law. Chapter 2 of the constitution is the cornerstone of the democracy and the state is mandated to promote, protect and fulfill those rights. Then you tell them that, however, those rights are subject to limitation in terms of section 36. In terms of then you tell them that section 33 of the constitution granted everyone right to administrative action, that is reasonableness. Department of Education is the state organ in terms of section 239. Everyone has a right to education in there. Section 239 is for constitutional. Everyone has a right to education in their official language or language of choice as long as it's reasonable, practical, based on section 29. According to section 3, subsection 2 of the Paja Act, stated that fairness of administrative procedure depends on the circumstances of each case. In the case of Maseta versus President Ngobo, J stated that the fairness is based on flexibility and practicability. Section 3, however, Section 3, subsection 1 of the Higher Education Act determined the development of the language policy framework for public higher education institutions. The language policy framework strengthens the development of African indigenous languages while sustaining already developed languages. The language policy framework was a response to Section 29, subsection 5 of the Constitution of South Africa, which determines that everyone has a right to receive education in the official language or language of their choices in public education institutions where education is reasonable, practicable, just like the way I have said. This section made it clear that there must be language equality in the highest learning institutions. The language policy framework is initiated to readdress the past, which is apartheid. Then boom, you are done. You get 8 marks. 8 marks for free. So this is how you should have answered. So maybe some of you may be wondering, but some of the things are not on the constitutional book. Ewen. What is this? This is the constitutional book. So constitutional book means that all things that are decided in other cases and in other legislation are subject to the constitutional book. So if you think that you read constitutional book, then you are done because you know constitutional book. Well, you do not know what is law. Law is based on constitutional book, but law is broader than constitutional book. So that's one you must know. So 1.2, let's go. Constitutional powers should be conferred on the lowest sphere of government, as this is the sphere closest to the people. We have 3 spheres. We have the first one in the parliament, we have a provincial, then we have a municipality. Municipality is the one that is closest to the people. So they are talking about municipality here. In the context of multi-sphere government in South Africa, what is this principle? Which provisions of the constitution, supported by relevant case law, confirms that this is how South African system of cooperative government is intended to function? Okay, so now we have to answer, right? We are answering for how much, for how many marks? For 17 marks, right? 17. Before I answer the question, don't forget that if you want more information, you can WhatsApp me on this number 0619842135. And then if you appreciation of the video, you can send me a betting voucher. You can send me a Hollywood 1 voucher, OTT or Blu-rays on this number again, 0619842135. Is to say I appreciate the video. Keep on, man. I'm very thankful for the video. Those who are thankful, you know. Then when you come to the chapter 3 of the Constitution, you can see the cooperative government. You can see section 40. You can see section 41, which stated everything. And then it means that we'll be dealing with the chapter 3 of what? Of the Constitution. Then when you answer the question, you'll firstly state it very clear that section 40 of the Constitution stated that in the Republic, government is constituted as a national, provincial, and local sphere of government which are distinctive and interdependent and interrelated. All spheres of government must observe and adhere to the principles in this chapter and must conduct their activities within the parameters that the chapter provides. That's when you start to answer. Then after that, you'll come and explain the doctrine of separation is the democratic principle. The power is shared between 3 branches, executive, legislative, and the judiciary. Then you go with the section 41 of the Constitution, requires all sphere of organs to present fees. Those are the how it should be in the cooperatives. Then you explain those all cooperatives until the last one, which is number V. You will be you have to summarize those one. Then after that, you go straight to explain the local sphere of government and how the local sphere of government municipality has been made and the function they are there in the Constitution. Then you go and explain the cases. You know, we have the cases of the Premier of Limpopo versus Speaker of the Limpopo Provincial Legislature. Then you explain that kind of a case when the legislature bill were considered, then constitutionality. Then you have explained that case is there on your book. I don't want to spend more time on something that is there on your book. Then the financial management, Schedule 5 of the Constitution. All those cases are that they are talking about. Then you go and explain another case, which is the case of Joseph and other versus City of Johannesburg and other, Local is closer to the citizens. One of the most important objectives is to meet the basic needs of all the inhabitants of South Africa. This was decided in the case of Joseph versus other. You go and you go and supply them with such a case. Is there on your book. So this one I won't be spending more time on this because you know it's there on the book. You explain the case of the Joseph, then you give the power of the local government in terms of section 1555, 145, 154, 1557. Then you give the power that it can be the power to intervene in the local in terms of 139. Then you give them the purpose behind section 155 of the Constitution, particularly subsection 3B, which guard the political interference. And you give example by the case of Matatiele municipality, others besides the President of the Republic of South Africa is there. Then the case is there. Then this one I'm not much into it because it's there on your constitutional book, so it will be very much easier. This one I've already showed you sections that you must rely on. So now we are moving to another question. We are moving to question number 2. 2.1 is easy, those 18 marks. Let's check another question which we can deal with it. Section 89, we'll come back to it. So let's keep question 2. It's much easier, this one. Let's go to another question. We'll do another video of question number 2. Let's deal with this one. Question number 3, compare and contrast the institutions established in terms of section 179, 178, 179, and 182, respectively, of the Constitution. You must provide a full discussion of the purpose, functions, and status of each of these institutions. Rely on appropriate case law to fulfill and convincingly substantial answer. So today we'll answer this question, and then on the next video we will answer question number 2, since you will say where is question number 2. So on this question, okay, let's go to question 3.2. What it says, explain the concept of constitutionalism, including all its features, refer to a case law and relevant provisions of the Constitution to provide a compelling answer. So this one, we will answer it. So we're going to answer this question number 3, and then question number 2, we'll deal with it on the next video. So let's start by which one? This one of those one. Let's go and check those number 1. In order for us, we just say, I believe that is a public protector there. So whenever we speak about public protector, it will be much easier to just search public protector. Okay, they said that 178. Well, let's check what 78 is talking about. Look like this one. Okay, 178 is talking about JSE, which is the Judicial Service Commission. Judicial Service Commission is the one that conducts the interview for the judges, but the judges are, the president is the one who appoints the judges with the recommendation of JSC. So that's number 1. Okay. Okay, let's check what the 179 talk. 179 is talking about the prosecution. The prosecution is under the state, under the NPA. Let's check another one, 182. This one is 180. Okay. This one is 181. Okay. This one is 182, which is the function of public protector. So now we know that we're talking about public protector, JSC, and the NPA. So let's go and answer. So let's say, just say question 3, right? And then let's start. Don't forget, guys, if you want more information, you WhatsApp us on 061984 2135. And if you can say donate to us, a betting voucher, Hollywood or what, on 070619842135. You just, as an appreciation, you just send a voucher to this number on the WhatsApp, then will be highly appreciated. And next time when even you need a document, we can able to supply you with a document, right? Because there's a lot of documents that you need, so we can able to support you with document if you can show appreciation. So firstly, we'll start with the Judicial Service Commission. Judicial Service Commission is created by Constitution. This is how you must answer. That the Judicial Commission is created by Constitution in Section 178. The main function is to play a role in appointing of judges and advise the national government on any matter that relates to judicial or the administration of justice. According to Section 174(6) of the Constitution, the President is allowed to appoint the judges of all the courts on the advice or recommendation of Judicial Service Commission. JSC is a fundamental role player in the independence of the judiciary. The SCA, Supreme Court of Appeal, reaffirmed that based on the principle of legality, the decision of the JSC, which include the appointment or non-appointment of judges, can be reviewed by court. In the case of Judicial Service Commission and another versus Cape Bar Council, the JSC is obliged to provide reasons for not appointing a candidate to value the transparency and accountability in order to be held accountable and to act in a transparent manner. But it is not mandated for JSC to provide reasons for anything. They made it only for appointing and non-appointing of candidate. Then you go forward by saying that the Judicial Conduct Tribunal is established in terms of Part 5, Section 19 to 34 of the JSC Act of 1994 as amended, to investigate the complaint of certain judges and make recommendations. Judge Hlope was found guilty of breaching Section 165 of the Constitution after influencing two justices of the court to influence the results. While Section 165(2) of the Constitution granted the judicial officers to apply the law impartially, for fair trial the judge should apply law where I'm reading. Okay. I'm no longer seeing where I was reading. For fair trial, the judge should apply law open-mindedly in the context of rule of law and not in the context of personal views, ideological views, or political affiliation. The judge must not favor or fear when applying the law. The judge must apply rule of law without pressurized by economic, social, and political circumstances. The judge must interpret the legal text without swayed by cultural, religion, or racial influence. However, interpret legal text is difficult owing to general language of the Constitution. Charlson P. argued that judges are always presumed to be impartial, although the litigation can rebut presumption. Then you can see I'm putting the footnotes, and this was decided in the case of South African Rugby versus the President. The judge, after hearing both sides of the parties, make judgment. Freedom under law versus JSC play a huge role in identifying partiality. Chopin instructed other judges to decide case in favor of person. The JSC dismissed the complaint, but the Supreme Court of Appeal emphasized that the JSC should have conducted investigation. The JSC play an important role in ensuring that the judiciary enjoy its independence. In the Van Rooyen case, the accused approached High Court on the basis that magistrate courts lack independence. The court held that the judges must hear the case without external influence and interference. In the Safru case, the court confirmed that the impartiality of the judge is a fundamental prerequisite for a fair trial. Judge's role is to make a judgment. Remember, the JSC is there to safeguard the freedom and to supervise the judges. So that is what the JSC is about. So you written this now, you have seen how we have written. It's a lot of paragraph just to feed you, and there are cases downwards which you can only if you are my friend. Okay, how to become my friend? You become my friend by donating a voucher or show some appreciation, then you become my friend. If you do that, you'll become my friend and I'll be your friend, right? You choose. You must never forgo. Don't forget this, that you can WhatsApp me for more information. However, you can be my friend by sending some vouchers for appreciation, which I've already provided the number. And I told you that if you don't want to be my friend, you don't show appreciation. People must show appreciation for what they have been given if it is useful. All right? If you come empty-handed, you are really showing that you do not appreciate somebody's work. So show some appreciation if it is really helping you. So the NPA and public protector, in order to know about them, then you'll become my friend. I told you that you become my friend, then you will know about the NPA and public protector. Then I'll give you all the cases of the NPA and public protector, but only if you become my friend. So let's go to another question. I've already showed you about JSC and then NPA and public protector. You have to become my friend in order for me to supply you with those recent cases and everything about it. Okay, then let's go to number uh, okay, I've already told you that I will choose this one. Explain the concept of constitutionalism, including all its features, refers to the case law and relevant provision of the Constitution. This one I've said that I'll put it in the next video. However, uh, number 2.2, critical discuss section 89 of the Constitution with reference to case law. The discussion must include comprehensive analysis of rationale for section 89, the consequences of this, as well as discuss how section 89 differs from section 102. So we just go to the section 89. Let me just say, I know that if I can say that and say that removal, I may go to those sections very fast. Yeah, removal of the president. That's right, section 89. So we can see section 89. Let's go to section 102 and see. Section 102. Motion of no confidence which take place in the parliament. So let me teach you about this. There's a motion of no, let me not teach you about the motion of no confidence. So this is how you should have answered this question. The president can be removed in terms of section 89(1) of the Constitution, which states that the National Assembly can adopt a resolution with a supporting vote of at least 2/3 of members to remove the president from office, only on the grounds of serious violation of Constitution or the law, serious misconduct, or inability to perform the functions of office. This falls under impeachment. The president can also be removed in terms of section 102 of the Constitution through a motion of no confidence, but the motion of must be also supported by members of NA. Motion of the no confidence can be lodged by anyone from any party. No party can block the discussion of no confidence. In Mazibuko Officer Sisulu, it was confirmed that in validness of Chapter 12 of the Rule of NA. Consider that South Africa used the closed list proportional representation electoral system If President is continuing gaining support from majority party, the motion of no confidence will unlikely to succeed. If she loses majority party support, the majority party can instruct other members to vote President out. President of the ANC, Mr. Cyril Ramaphosa, was elected, instructed all ANC members to support motion of no confidence. The former President Jacob Zuma was left with no choice but to surrender, to resign. This also happens to former President Thabo Mbeki. I won't talk much about this one. You know that if you want to become a friend and get more cases about this one, you will have to become my friend, then I'll give you more cases. It's very crucial to become my friend so that you gain from those cases. You can become a friend by being a member, or you can do this by uh, just providing me with some voucher nyana. Then of course you are my friend. Then explain the concept of constitutionalism, including all its features, refer to case law and relevant provision. Lastly, don't forget, guys, if you want to become a friend to get the documents and the cases, you know what to do here. You can also become a member by subscribing, not subscribing, by buying a membership, or you can become my friend by just supplying me with a betting voucher. You must know that the money must be reasonable, because you know in law everything must be reasonable. So I'll do part 2 when I explain those others that I have not explained, and then you will be seeing what we are doing. Thank you very much for watching this video. Part 2 will be coming very soon.